Man, I can't even go run errands without something going on. Okay, we have a lot of documents to go over, guys, and one of them includes a motion to dismiss that quite a few of us have actually been waiting for. Let's go. Hey guys, this is Jules with True Crime Reactions. Now, I was out running errands, grabbing dinner, grabbing groceries, and then got an alert on my phone that we had this many drops. Now, I know that a lot of you guys have been noticing that there's been server issues on this website. And for the longest time, we've had issues with all of these right here actually showing up. Now, earlier today, I checked this a couple times. Everything seemed to have been okay then. But the last official thing that we got from these published documents was this order to vacate hearing. Now, there was an evidentiary hearing that was supposed to be scheduled on August 2nd. And remember, whenever we were going through the last document dump, there was some handwriting next to Judge's name that stated that the court was worried or had questions about the transportation of the evidence. Well, it seems like that was going to be addressed on the 2nd, but now it's going to be addressed in an in-person hearing that is already scheduled for August the 18th at 10:30. So even though the evidentiary hearing itself has been canceled, the subject at hand that still needs to be discussed is still going to be discussed. It's just going to be in an in-person setting at this point. Now, I do know that there was a response to the order for stay that was posted, and I know some channels went over it. I have just been really super busy. Most of you guys have seen it by now. They're going to argue these things. And honestly, unless some new revelations happen, I just don't feel like it's necessary to play the game that they're playing, because they're going to argue every single side, every single aspect multiple times. And there's only so much they can say before they start sounding like they're just broken records. Now, after the order to vacate the evidentiary hearing, we have the motion to temporarily seal exhibits. Now, we knew that the information for the grand jury was going to have to be coming into play really soon, and that there was like a deadline given for everything to have been put together. Now, this is a order to temporarily seal the exhibits 1 and 2 that are attached with the state's response to the defendant's 5th and 6th supplemental request for discovery. And if you guys remember, they were very, very vague. And ever since these 5th and 6th discovery requests posted is basically whenever the server started having like super for real situational issues. Because see, they're very just vague. Everything is being withheld so that the public can't see it, which is fine. So while there are lots of documents to go over, there's really not a lot of new information because everything is it's sealed. So it's not like we can really see what's going on. Now we have this motion to dismiss. And this is a 23-page document. So I'm going to end up I'm going over this now in this one recording of me going over these documents, but there's probably going to be a lot of this cut out because I don't feel like 23 pages is worth going over, and I know that this is going to have something to do with the grand jury. This was basically the next step that people were waiting on for the motion to dismiss, to appeal the grand jury indictment, all of those things. That was what the expected next step was. At least whenever it comes to the people that I converse with about this case, that was the consensus there. So this to me means that everything was already given over to them about the grand jury, or at least everything that they were anticipating to have received about the grand jury, because they were literally waiting for those items to be obtained by the defense before they could properly file this. Without them having it for a certain amount of time and being able to have gone over it and not being told, well, you only had it 30 seconds before you filed this, that wasn't enough time to even do any sort of work on even checking anything. This to me means they've got it, they've gone over it, and now they've found problems. So let me go ahead and go through this and see what exactly it is that they are arguing here. Comes now Brian C. Koberger, and by and through their attorney, J. Weston Logsden, Chief Deputy Litigation. So this is written pretty much by Mr. Logsdon, hereby moves this honorable court for an order either dismissing the indictment in this matter or to treat it as a presentment and remand for a preliminary hearing before the magistrate. Okay. This motion is made on the grounds that the grand jury was misled as to the standard of proof required for an indictment. Okay, that's an interesting tactic, I guess. Issues. The Idaho Constitution, Article 1, Section 8, NIC 19-1107 set the standard of proof for a grand jury at beyond a reasonable doubt based on the plain language of the statute. A legislative history also supports a beyond a reasonable doubt standard. The Idaho Supreme Court cannot adjust the standard of proof as it is a substantive right. The failure to properly instruct a grand jury as to the standard of proof is grounds for dismissal of the indictment. A. The grand jury was erroneously instructed with the standard required for a presentment. Thus, this court could treat the indictment as a presentment. Okay, arguments. The Idaho Constitution, Article 1, Section 8, and IC 19-1107 set the standard of proof for a grand jury at beyond a reasonable doubt. And then they have this little paragraph, and it states, the grand jury ought to find an indictment when all the evidence before them taken together, if unexplained or uncontradicted, would, in their judgment, warrant a conviction by trial jury. So it's just like in every other trial, every other type of jury, it has to be without any sort of doubt, beyond a reasonable doubt. If there's no explanation, if there's nothing that can be said to contradict what's been put in front of them as evidence, that is definitely beyond a reasonable doubt. So I'm pretty sure you guys understand exactly how all of this works anyway, but that's just how I'm trying to interpret this little sentence. Okay, let me go ahead and go through all of this legalese and all of these little notations and annotations that they're placing in here, and let me see what kind of actual real details I can find. Okay, so I'm going to be pretty honest here. It doesn't really sound like they have much of an argument so far. Like, really, to me, it just kind of is like giving all these examples about what reasonable doubt is like supposed to be and what it means whenever a grand jury finds someone guilty beyond a reasonable doubt in order for them to be convicted and then have to now go to actual trial. And it's basically claiming that the way that the rules are written, it's not clear enough to the layperson what their job really is whenever they're in a grand jury. It's basically like how I'm interpreting it. But at this point, I'm on the beginning of page 6, and it just seems like they're trying to state the way these are written. How do we know the jury understands what the actual goal of a grand jury is when it comes to what they're going to be doing with an actual indictment being handed down? That's how I'm interpreting this. The defense does not, by all this, intend to bury the lead, but merely show that under the usual approach of statutory interpretation, there is no reasonable doubt as to what a grand jury should be instructed. And that's kind of the sentence that made me decide that what I was thinking was correct. And that's not an argument, honestly, because this is 2023. Everyone knows how juries work. Everyone knows that whenever you're in a court system and you're listening to evidence on any sort of, seated area where you have to give a decision about something, that you're not in there to give somebody an award for being, the best Boy Scout. You're in there to listen to bad things and to decide if the person that's sitting in front of you is guilty of doing said bad things. Everyone knows that. So this argument so far, they don't have one, in my opinion. But okay, I'm gonna keep on looking. Okay, and now they're going into stuff about guilty plea or trial by combat. Like, why are they talking about this stuff? And now they're trying to bring up stuff that was written about things that happened in the 1600s to the 1800s. Why? Okay, see, this just seems like a really, really, really long document that doesn't have any stance so far. And I'm on page 9. And guys, you know that I've been really questioning a lot of things when it comes to the way this case is going. But I am not confident whatsoever in this motion to dismiss based on what's being said right now. They're bringing up all kind of stuff to me that honestly just isn't an argument. It's all about the probable cause to believe a man is guilty. Okay, but like I said, everyone knows what the hell you're going in there for. Whenever you are on a jury, you know what you are in there to do. And if any of them had any doubt, then that's not how it would have gone. Now, we actually, honestly, I want to look something up. How does a grand jury thing? How does a grand jury vote work for indictment, Idaho? Because I want to see does it have to be unanimous? I'm guessing, right? Like nobody can have any sort of doubt. An indictment may be found only by agreement of 12 or more jurors. It can be more than 12 people. I probably should have looked up this stuff. I mean, I believe I did look up this stuff, but none of it really stuck into my brain. I'm trying to see just to make sure. Because look, guys, like I've really been questioning a lot of this stuff because the stuff in the PCA is not awesome to me at all. And I have a lot of questions about the DNA on the knife sheath snap. I really do. I have a lot. Okay. A grand jury must consist of 16 qualified jurors of the county in which the grand jury sits, but 12 or more members constitute a quorum. A grand jury can deliberate and take action if a quorum is present. So 12 minimum, 16 maximum, but what is the definition of this word? That is not. Minimum number of members of a deliberative body necessary to conduct the business of that group. So yeah, same difference. 12 minimum, 16 max. And after they are sworn in, it states right here, charge to jury. After the grand jury has been sworn, the court must give a charge to the jury stating in detail their powers, duties, and authority, and any other information which the court deems proper. The charge must be given orally to the jurors, and a written copy must be given to the presiding juror. And the presiding juror is like the leader that's chosen to kind of like be the speaker for the entire jury selection. So they are told verbally and in written form what exactly is expected of them. So, I mean, I don't see anything of note or detail in here that has anything to specifically do with Brian himself when it comes to what was presented to the grand jury and what the rebuttals are to those things. We're on page 15, and I have not even seen his name. I haven't seen the defendant. I haven't seen Brian Kohberger. I haven't seen anything pertaining at all to Brian Kohberger. And see, it states right here, the failure to properly instruct a grand jury as to the standard of proof is grounds for dismissal of the indictment. But unless I've missed something, I'm not seeing them giving any proof of anything. This is just giving a whole lot of different examples of different ways and different situations that have something to do with the grand jury and taking away the indictment with for problems that have been, uncovered in the past with past cases. I'm just not. Counsel can find no case that permits the courts to determine the standard of criminal matter. Okay. Standards of proof are considered substantive in every context except apparently in dealing with conflict of laws. Okay, but you're not. I'm not seeing where they are like specifically stating anything specifically aimed at what went down with this specific grand jury. So they're not technically. The new Idaho case to mention the distinction was, okay, see, again, despite disposing of this argument, the court then made the following comment. Only requires that the grand jury find that there is a reasonable ground for believing that a particular individual named or described in the presentment has committed a certain public offense. I mean, okay, reasonable ground for believing someone could is definitely not the same thing as reasonable doubt that there couldn't be a possibility of it being possibly anyone else. This isn't giving me anything specific to what actually happened in Bryan Kohberger's grand jury. So stating the failure to properly instruct a grand jury as to the standard of proof is grounds for dismissal of the indictment. Unless there's information in the transcripts that they heard being given incorrectly whenever the information in the charge to the grand jury was given verbally and those transcripts were then given over and the recordings were given over, unless there's something specific that they heard, then I don't know why else they would be trying to use this argument. But it is a very, very, very long argument for something that I'm not actually seeing proof for. The grand jury was erroneously instructed with the standard required for a presentment, thus the court could treat the indictment as a presentment. There is one final wrinkle in this error that is worth considering. As mentioned above, there is in Idaho a thing called presentment. It does not appear from the authorities in Idaho that this thing is well understood. However, in the words of one justice, it is the only sort of accusation any grand jury in Idaho has ever produced. Okay, so it's a term that's not very well known or understood, but it's the only sort of accusation a grand jury. If it's the only kind that has ever happened, then how is it misunderstood? That's confusing. A presentment permits the defendant to request a preliminary hearing. So, if anything, it seems like they're trying to just get their preliminary hearing back on the schedule. They kind of want to go about this as if the grand jury situation never even happened and just go back to preliminaries. Conclusion. Over 150 years ago, Idaho joined the state of California in adopting the Field Code, which is all of this stuff that, all these things that I'm still not understanding why this is 23 pages for. I'm really just not. Thereby adopting reforms to the grand jury system intended to restore to that system its function as a bulwark for freedom. The strange history that follows in this state, just as every other state with the same statutory scheme, is both tragic and unconstitutional. No court had the power to decide that the legislature had made it too hard for grand juries to do their work and change the sufficiency of evidence required to indict. Mr. Kohberger is asking this court to recognize the long string of error that led us here and give back the people of this state the protections they are owed. The indictment in this matter should be dismissed or remanded for a preliminary hearing. And I mean, okay, I really get that they're just trying to do their jobs here, guys, and I might be wrong because, look, I'm no lawyer. I don't ever claim to know exactly what this is all about. I'm literally, the channel is literally called True Crime Reactions because I'm reacting to the things that are being given to the public. And I have a little bit of knowledge on the forensic science part of it. So I feel like I have a good balance of kind of knowing a couple things, but also having an open mind of not having certain parts of the knowledge that is needed. That way that I am more open to asking questions and maybe asking questions that are a little bit tough for other people to ask, which I'm totally fine with. And I might be incorrect about how I'm going over this document, but I'm not finding anything specific when it comes to Bryan Kohberger in this entire thing. And it just basically sounds like a whole lot of nothing just to say that the grand jury didn't know what they were doing. I mean, that's basically what I'm getting at there. Okay, well, that was slightly disappointing, but let's go ahead and move on to the next one. Looks like we have a second motion to stay proceedings. Now, we already had one approved, a 37-day one. Now, this is being written by Ann Taylor, makes a second request for stay of proceedings pursuant to Idaho Code. Now, this is being based off of the failure of Title II of the Idaho Code. Title II provides statutory authority and requirement for convening trial juries or grand juries. Mr. Kohberger alleges failure to full compliance with Idaho Code 2-208. This statute states that individuals must be randomly drawn from a county jury list and that the jury commissioner shall draw a requisite number of qualified jurors for one or more panels or for a grand jury. The statute further requires, upon receipt of the direction and in a manner prescribed by the court, the jury commission shall publicly draw at random, by use of a manual, mechanical, or automated system, from the county jury list the number of prospective jurors specified. The number of potential jurors appearing for potential selection impacted the seating of grand jury that heard the case. Based upon review of the grand jury convening process, apparent failure occurred. The number of potential jurors appearing for potential selection impacted the seating. I wonder what that means. Idaho Code 2-2083 requires that the qualification questionnaire form must be completed and returned to the clerk or the jury commissioner within 10 days from the date of mailing. The qualification questionnaire form shall elicit the name, address of residence, and the age of the prospective juror, whether the prospective juror is a citizen of the U.S., a resident of the county, is able to read, speak, and understand English, has any disability impairing his capacity to render satisfactory jury service, and has lost the right to serve on a jury because of a felony criminal conviction. Okay, so all the like regular things, all the other normal check marks that you would have to be checked off on. The qualification questionnaire form shall contain the prospective juror's declaration that his responses are true to the best of his knowledge and his acknowledgement that a willful misrepresentation of a material fact may be punished as a misdemeanor. Based upon review of the grand jury materials and process, it appears a failure has occurred. And I guess we're just not going to hear about it because, yeah, see, under seal. Further, other irregularities exist within the grand jury process, and further investigation is necessary to determine the impact. So they're wanting a longer stay, I guess, because they are claiming that there were failures that occurred in the grand jury selection process. And the motion to dismiss doesn't have really anything to do with the grand jury process, so I don't know why they wouldn't have added that as part of their motion to dismiss. Okay, now let's go on to state's response. State's response to the, okay, so this is for the 5th and 6th supplemental requests for discovery. And of course, it just has all the document names, and then it says the state has and will continue to provide discovery in accordance with Idaho Criminal Rule 16. And then, under seal, so can't see nothing. Okay, motion to file attachments. Let's see. Motion to file attachments to defendant's motion to dismiss indictment. Okay, so this is attachments for their motion to dismiss. And of course, it's all going to be done under seal. And again, I could be wrong, guys. I don't know the legalese and what all that stuff means, but it really did seem to me like 23 pages of a bunch of just cases being talked about. Okay, motion to file the affidavit attached to defendant's second motion to stay proceedings under seal. So, more sealed attachments that we can't see. Order to file the affidavit. Order sealing jury panel selection. Now, of course, we're not going to see this. We might never see this. Now, once this trial is done and over with, I don't know if this stuff is going to end up becoming public record, but usually once everything is done and over with, people start talking. So, order providing and sealing jury panel selection list. So, this is the state handing over and sealing the grand jury panel info. Okay, temporary order for exhibits 1 and 2 of the state's response. Okay, so this is just, things constantly being sealed away. Okay, now a motion to compel, notice of defense of alibi, or alternatively to bar certain evidence. Okay, so they've done an alibi demand, and now they are doing a motion to compel the same way that the defense has done several motions to compel. The state is now doing a motion to compel the alibi or to bar certain evidence. Now it states here, comes now the state of Idaho by and through the Latell County prosecuting attorney. moves the court for an order compelling the defense to comply in full with Idaho Code 19-519 and ICR 12.1 and provide the state with notice of an alibi that may be offered herein, said notice to include the specific place or places at which the defendant claims to have been at the time of the burglary and homicides in this case, the names and addresses of all witnesses upon whom the defendant intends to rely to establish such alibi. As the court reflects, the state filed its request for discovery disclosure alibi demand on May 23rd of 23 and served the defense on the same day. The parties subsequently stipulated to extend the statutory time for the defendant to provide notice of alibi and comply with Idaho Code. On July 24th, the defendant filed a notice of defendant's response to state alibi demand. This document does not comply with the requirements of Idaho Code, in that it does not specify a place or places at which the defendant claims to have been at the time of the offenses herein, nor does it provide names and addresses of witnesses upon whom the defendant intends to rely, which is true. He was very vague and just said, whenever everyone that the state calls and whenever all of the state's evidence gets examined or cross-examined, that's whenever you guys are going to know what my alibi is. That's basically how I read it. The state recognizes that the defendant has a Sixth Amendment constitutional right to call witnesses in his or her defense. However, as noted in both of these cited cases, the defendant's right to call witnesses in his or her defense is not unfettered, and the state has a legitimate interest in obtaining timely and complete discovery response from the defendant. As the Juarez court also observed, if requested by the state during discovery, a defendant intending to offer an alibi must file notice where the defendant claims to have been at the time of the alleged offense and the names and addresses of the witnesses whose testimony will support the defendant's alibi. As evidenced by the defendant's July 4th, 2023 notice of defendant's response to state's alibi demand, the defendant has failed to comply. It is important to note that scheduled October 2nd, 2023 jury trial is barely more than 2 months away. If the defense intends to rely on alibi, it is essential that they be required to provide prompt notice so that the state can fulfill its obligations under Idaho Code to investigate and respond to the notice of alibi. Any further delays will substantially prejudice the state's rights. Similar to the situation in Juarez, the state has no idea how the defendant's notice regarding alibi constitutes an alibi, and as observed above, the state is unable to comply with ICR 12.1 and Idaho Code 19.519 because based on the lack of information in this case, we don't know how this is an alibi at all. Which is true. Because, it can be looked at both ways. Him standing silent is an extremely smart tactical move. Him still standing silent and choosing not to give an alibi is still, to me, another could be a very smart tactical move. But they're still the same way that we're sitting here claiming, oh, well, it's his right to have everything that's being held against him be shown to him. The state doesn't have any right withholding any evidence. To me, it kind of has to go both ways, because if you're going to be sitting here trying to claim that everything the state has on you is false, that everything they have is wrong, and they're still pushing to say, no, we have what we have that can back all of this up, and you're still telling them that they're wrong, well, you have to show why. And you can't just be like, oh, it's going to come out whenever your people start slipping. That's not how, honestly, it should work. So I know that people are going to say, and I'll halfway agree, that this is still a smart tactical move, but I still stand by, if I had a real for real alibi that I know that could be verified, I would be screaming it. So they are right. He did not comply with what was asked. So now they are having to do this to try to get the judge to compel it out of him. Now, the thing is, if there is an alibi that he is expecting to have come out, does Ann Taylor know what it is? Because if he's not even telling his own attorney, then no amount of compelling is going to do anything. Because if he's keeping it inside of his head and he's not letting it out, then what are they supposed to do? They can't lie. They can't make one up. It's just like all this stuff that needs to be handed over from the FBI. You know, a county judge or a sitting judge in Idaho can only do so much whenever it comes to telling the feds what they need from them, you know? So I don't know. I guess we're just going to have to see how all of this goes. Based on the above, the state respectfully praised the court for an order compelling the defendant to comply in full with Idaho code by filing a notice specifying where the defendant claims to have been at the time of the alleged offenses and the names and addresses of the witnesses whose testimony will support the defendant's alibi. Given the time constraints, the state praised that the court direct the defendant to comply no later than 10 days from the date of the court's order, and that the state be allowed, pursuant to Idaho code, to provide the defense written notice of names and addresses of witnesses who the state intends to rely on to establish the defendant's presence at the scene of the offenses, or any other witnesses to be relied on to rebut testimony of any of the defendant's alibi witnesses no less than 10 days before trial. So they want the alibi to be able to be turned over within 10 days of the court's order if the court does so order. And they're claiming that once that's given to them, then they're telling them that after they do their own research, they're then going to provide the defense with a list of witnesses and reasons why they're going to be using those witnesses to rebut whatever Brian is going to claim his alibi is, which is sort of how it works. That's how I've kind of always seen it work. So I guess we're just going to have to see. Alternatively, the state prays for an order of this court pursuant to Idaho code prohibiting the defendant from presenting any evidence, whether by direct or cross-examination, in support of any claimed alibi other than from the defendant himself. Hold on. The state prays for an order of this court prohibiting the defendant from presenting any evidence in support of any claimed alibi. Okay, so I think this means that, okay, so you know how he's claiming that Bethany has exculpatory evidence? They want the court to tell Brian, yeah, you're claiming that Bethany has exculpatory evidence, and that's going to be basically like your alibi and your reason why you're going to be exonerated. You know, all those terms that we've heard so much in this case, right? They want the court to tell him, you can't use whatever Bethany's going to say up here. You have to provide your alibi yourself. You have to tell us yourself where you were, because then everything that you say then has to be validated, which is true. That's how I'm interpreting that. Anyway, okay, so now we're on the last one, which is a notice of hearing. Because remember, the evidentiary hearing that was supposed to happen on the 2nd was vacated, and they said it was going to be taken care of in an in-person hearing. And this is basically just the notice of said hearing. Okay, so on August 18th, they're going to talk about the state's motion for a protective order that was filed on June 16th, the state's motion to reconsider order staying time for speedy trial filed on July 17th, the state's motion for scheduling order filed on July 17th, and then the state's motion to compel the alibi is also going to be discussed on the 18th. But that looks to be it when it comes to the new documents. Let me go ahead and reload just to make sure. Yep, that is it. Thank you so much if you have watched to the end of this video. I know that you guys are used to me like having my face in these, but it has been like 107, 110-ish in Texas over the past like 2 weeks or so. And there's just a couple hours during the day, and it just so happens to be the hours that I have time to do these, that it's just a little bit too warm in here. My air conditioners just really cannot keep up, especially with the feel like. I mean, we've got trees and stuff, but it's just not enough. And I don't want to be just like all sweaty faced on the camera, but I'm going to try to get some done in the early morning hours tomorrow before work. I have a couple more things I want to discuss. I've been listening to some things that have been being said by WSU Kim, and I've been given some back information on a couple of things, and I've been questioning a lot, and I think I'm almost ready to have a discussion about it, or at least put my thoughts about it into a video. And if not tomorrow, then it'll definitely be coming extremely, extremely soon. But yeah, those are the new documents. I still feel as if the motion to dismiss doesn't have anything substantial in it. And I could be wrong. but that's just what I'm getting from it. I do want to know what you guys think, especially about the motion to dismiss. Let me know. See y'all.